The passing of Justice Ruth Bader Ginsburg leaves open a vacancy and a confirmation fight for the Supreme Court, one occurring during an already contentious election and a year that saw the impeachment of a president and a global pandemic. This isn't the first time we've had a vacancy in the nation's highest court during an election year. Here to discuss the history of these vacancies is Professor David Greenberg from Rutgers University. He is the author of numerous books about presidents, including Nixon's Shadow, The History of an Image, and Republic of Spin. That's another book he wrote. Republic of Spin, An Inside History of the American Presidency. And he's also a contributing editor at Politico magazine. So, Professor Greenberg, thanks for being on this show.
Sure, glad to be here with you.
So whenever these vacancies happen and there's a confirmation process, it seems that there's so much at stake in these processes right now. What were vacancy nominations and these processes like prior to the 20th century?
Well, it's really been a varied history, which often gets forgotten. For most of the 19th century, it was a pretty political process, and it was not uncommon for a president's nominee to the Supreme Court to be rejected or otherwise fail to make it onto the bench. I think something like a quarter of nominees failed. And especially in the years surrounding slavery, the antebellum years, those questions could loom large in confirmation fights. Then what's interesting in the 20th century, you have really the beginnings of the rise of the strong presidency with figures like Theodore Roosevelt and Woodrow Wilson. And a lot of society, including Congress, including the press, becomes somewhat more deferential to presidential authority. So for, I would say, the first 2/3 of the 20th century, you have a pattern of deference where there isn't a lot of controversy. I mean, there are some individual cases. Maybe we could talk about Hugo Black, who was Alabama senator who had been in the Klan as a young man. He makes it onto the court anyway. So it's not that everything is completely smooth sailing, but you don't see anything like the contentiousness we've had. And then the thing I'd point out is you often hear people saying, oh, this all started with Robert Bork and the 1987 fight over his nomination, which of course failed. And although that gave us the term borking for trying to block a nominee, Bork wasn't really the start of anything. The current contentiousness really goes back to the late 60s. And there were a number of fights back then, both under Lyndon Johnson as president and then under Richard Nixon after him. That really is what sort of created the dynamic that we see today.
That's interesting. So first, you said about a quarter have failed, which is true. We're seeing throughout history, presidents have had a 77% success rate in presidential nominations, but many presidents in the 19th century and 20th century have been rejected or have had their nominations rejected. That includes James Madison, John Quincy Adams, James Buchanan, and then the 20th century, you named a few, but Eisenhower, Johnson, they've all had failed nominations. And that's very interesting. I understand that one of the nominees under Johnson was Abe Fortas, which I believe there were some corruption, I think, concerns about him, as opposed to ideological concerns.
Well, it was a little bit of a cover story. So Abe Fortas was a close friend and kind of confidant of President Johnson. He was a big Washington lawyer with Texas roots, and he was actually on the bench. He was an associate justice. And then in the last year of Johnson's presidency, Earl Warren, who had been Chief Justice since the early 50s, appointed by Eisenhower, announced he's resigning. And Johnson wants to elevate his friend Abe Fortas to the Chief Justice. And there is a huge controversy. There are some questions about various financial issues, but really the main point of contention is that he was a part of this Warren Court. The Supreme Court under Earl Warren, as probably a lot of people know, was a very activist court. It really transformed the nature of American society in the 50s and 60s, starting with landmark decisions like Brown versus Board of Education, which said that separate schools for blacks and whites was unconstitutional, and going through a whole series of decisions on prayer in school, on voting rights, on free speech. And Fortas was sort of being held responsible for a lot of these decisions, including for some that had occurred before he got onto the bench. And if you look at the whole discourse, the hearings for his elevation to Chief Justice, you can see that it's there. The Southern conservatives, both Democrats, there were still a lot of Southern conservatives in the Democratic Party, as well as Republicans, kind of conspire or join forces, maybe it was fairly above board, to block his elevation. There was clearly an ideological element to this. The final chapter is, so Johnson has to pull the nomination, doesn't get it through. Richard Nixon gets to make his own appointment. Warren Burger becomes the next Chief Justice. But the Nixon people also then use some of the stories about Fortas's financial dealings to basically force his resignation altogether. And so Nixon gets an extra pick out of this. So it was a really political hardball set of developments.
That's interesting. So from what you're saying, it sounds like the liberals, the Warren Court, which had moved to the left, basically a lot of these fights began because of an attempt to rein in the court after the Warren's tenure. Is that kind of what you're saying?
Yeah, I mean, you could say that at bottom, it really was an argument about jurisprudence. What should the court's role be? What kind of philosophy should govern their decisions? And you saw under the Warren Court, although probably not as radical as the conservatives made it out to be, you definitely saw an expansion of the court's role, and it sort of taking a more aggressive role in expanding rights. And terms like judicial activism and legislating from the bench had been used before, but ironically, they'd often been used by liberals saying that conservatives on the Supreme Court were abusing their power. Here you see it being sort of flipped around. And Richard Nixon in 1968 runs, he runs on many issues, but it's a big issue for him in a way that the Supreme Court really had not been a presidential campaign issue much before that. And Nixon says, we're going to appoint judges who don't legislate, who interpret the law. It's the same refrain that the conservatives and Republicans articulate today. And so I think today's conflicts really have their genesis in the conflicts over the Warren Court and what it did to American law and society.
Right. So a question I have for you is, in the past few decades, and I guess we might have to go back to when you mentioned the late 60s on, is there a difference in the way both parties approach confirmations? And I say that because there are conservatives who will argue that Justices Sotomayor, Ginsburg, Breyer, and Kagan were appointed relatively easily without much controversy, but then they'll point to Clarence Thomas, Kavanaugh, Gorsuch. They'll point to those things. And then there's also the controversies about the filibuster and the removal of that. at the lower level. So how would you say that do both sides kind of approach it from an even playing field, or is one side kind of did one side start it and the other side is now both sides are doing it? How would you describe that?
Yeah, I think both sides basically play by similar rules and similar dynamics, which is they like to pretend that they are operating only on the basis of, is this a deserving justice, a deserving nomination? When in fact, they are very concerned about what politics that judge or justice will show from the Supreme Court. And so on both sides, I think there is sort of this effort to kind of mask the political questions that are going on underneath. Now, I would say in the last 2-3 presidencies, that facade has started to crumble. It's become increasingly difficult to maintain the pretense that you are merely going on some kind of extra political criteria. But if you think about it, why were these people blocked? Clarence Thomas, they couldn't make the case. I mean, some of them tried, but it wasn't enough to say, well, he's going to be a conservative justice and he's replacing Thurgood Marshall, this great liberal lion, and that's going to fundamentally change the character of the court. So that's why we're against him. No, they tried couching it in terms of qualifications. He was new to the bench. He got a low rating from the American Bar Association. Then they brought out the sexual harassment charges, and that was said to be disqualifying. And so you've seen, even some of the justices who made it on relatively cleanly without too much controversy, to the extent that there was questioning, to the extent that they were undermined, it was on, well, what about financial dealings? Did you pay your taxes here? Or what about this investment? Did you have a conflict of interest? So there's been sort of an incentive, because we have this pretense that the judiciary is divorced from raw politics. It has created this incentive to use sort of the politics of scandal to go after nominees. And then one way that presidents fight back, they try to immunize their nominees from those attacks. Well, I'd say in a few ways, but one is just by sheer academic excellence. So this accounts for why so many of them are coming out of, Harvard and Yale Law School these days. It accounts for why so many of them have served on the D.C. Circuit Court of Appeals. There's not nearly as much variety of background. Earl Warren was a governor. Sometimes senators went on. But now, they all come through the same pipeline, whether left or right. And then I would say the other thing that is often done is a use of identity. And it's understood that an African-American nominee, a female nominee, a Puerto Rican American is going to be harder to impugn, because there is, that provides a certain patina of historical path-breaking quality and so on. So, for example, when Sandra Day O'Connor is appointed by Ronald Reagan as the first woman on the court, Democrats don't really give her a hard time. They sort of understand the politics of that appointment. And even though there is an understanding that she's conservative, they feel they're kind of politically defeated. So I think this is the dynamic, and you see it on both sides. You see when Republicans are controlling the Senate and a Democrat is in the White House, it's like a mirror image of what happens when a Republican's in the White House and the Democrats control or have a strong voice in the Senate.
So it's been. Sorry. Mm-hmm.
Go ahead.
No. After you.
One more thing. If you look just at the Bush, Obama, and Trump years, you will see in terms of the numbers of senators from the opposite party who are supportive, who vote for a nominee, you'll see it becomes increasingly a party line vote. So there is we talk about polarization happening in all aspects of political life, but you really see it in just the numbers of, some Democrats voted for John Roberts, a bit fewer, I believe, voted for Sam Alito, fewer for Gorsuch and the Trump nominees. And on the flip side, I think fewer Republicans supported Obama's nominees than they had Bill Clinton's nominees. So you see this polarization, this unwillingness to even consider breaking ranks, intensifying over the last few decades.
Yeah. So in the last few years, people have talked about how the use of the filibuster during President Bush's first term, that was used a lot to block his nominees to the circuit courts. And then in 2013, where Senator Reid broke the filibuster for appellate nominees, and then eventually the nuclear option led its way to the Supreme Court. Do you think that were those moves really unprecedented? What was the impact of that? And a lot of people would say that this was kind of a bad tactical move at the time because now it's come back to haunt the Democrats.
Look, it's very hard. I think there's always this illusion that some kind of clever procedural stratagem will help you in the present moment. And what should be obvious, but they always seem to forget, again, on both sides, is that the tables could be turned, in a year. And we've had such closely divided Senates and such closely divided government, really ever since like Bush v. Gore. There was a period in the Bush administration where, somebody retires, or Jim Jeffords of Vermont, a senator, changed party, and this sort of tips the balance of who controls the Senate. We have a lot of very closely divided institutions, both Congress and then, the White House, presidents who are elected by a hair's breadth, by winning the popular vote, losing the popular vote, but winning the Electoral College. So all this very closely held division should be kept in mind, because it should be obvious that the tables could turn very quickly. But when you're in the moment and when you're frustrated that the other side is obstructing your agenda, it's very tempting to say, okay, well, let's do away with the filibuster. The rules can serve either side. Right now, Democrats, of course, are talking about expanding or packing the Supreme Court should Biden win and should they get a Democratic Senate. And, the unanswered question is, well, what about 4 years? Let's say the Republicans get control. Do you want them to do the same thing? When they talk about the nuclear option, the metaphor of an arms race, I think, is apropos. I think, look, you could criticize Harry Reid for doing away with it, but if he didn't, somebody else would have felt pressure to. There is this pressure to escalate. And I think it's unwise. I think it's better to try to keep the rules much as they are, and to at least have an informal understanding that we're going to operate within these accepted rules and norms. But both sides find that hard to live with. Most recently, of course, there was the case of Mitch McConnell in 2016 refusing to give a vote to Merrick Garland for I forget if it was 8 months, several months on end, which was almost unprecedented. I think it was similar to sort of what happened actually under Lyndon Johnson when he could not get a Fortis confirmed, although at least there were hearings there. Both sides, I think, have done their part in eroding the sense of senatorial goodwill and tradition that, at one point probably did count for a lot more than it seems to today.
So you mentioned the increasing polarization under Presidents George W. Bush and Barack Obama, and I think as a measure of that, there was a time when the U.S. Senate confirmed Ruth Bader Ginsburg 96-3. This was in 1993, so that seems like eons ago. So one thing everyone's talking about is whether what the Republicans in the Senate are doing is hypocritical, in the sense that whether it's fair that to block a nominee by a Democratic president in 2016, but then to confirm a nominee now that a Republican is in office. And I've seen a lot of different things on this. There was a Congressional Research Service report that said that this is the 14th time. So there have been 13 times a vacancy has happened during election years. And I believe 7 of those times happened during same party having the White House and the Senate. And 6 out of 7 of those times they passed it, or they confirmed the nominee. 6 times it was when the Senate and the Senate and the White House were different parties, and only 1 time was confirmed. What do you make of that? What do you make of the history and the claims that this is kind of a hypocritical move?
Well, look, I think the hypocrisy of McConnell and the Republicans lies in not having brought Garland to a vote in 2016 and then plowing ahead, in not quite record time, but quite rapidly to make sure that Amy Coney Barrett will get a vote. Looks like before Election Day, but if not Election Day, then shortly thereafter. The prehistory, pre-2016, really doesn't apply much, because it was in 2016 that McConnell, articulated this rationale. Oh, we're in an election year, so therefore we shouldn't bring this nomination forward. That was a completely novel claim. There was no, there's no reason why, when you have someone die in, February or March of 2016, that you're so close to the election that you can't have the vote. So Democrats, I think, are rightly crying hypocrisy this time around, because we're even much closer to the election. So the argument that the winner of the presidential election should get to make the next nomination is what McConnell said in 16. And if he were to apply it today, of course, it would mean holding off. Now, there is, I think, a lesser hypocrisy or error on the Democratic side. Some Democrats are saying, Mitch McConnell, we just want to hold you to the rule that you articulated 4 years ago. That's fine. That's, I think, what they should be saying. In the presidential debates, Joe Biden and Kamala Harris didn't really get into the intricacies of Merrick Garland and Senate tradition and so on. They found it simpler to just make the argument the next president should decide. So that, I think, is a mistake. It's an intellectual inconsistency, because in effect, they are now adopting McConnell's position of 16, rather than saying, Mitch McConnell, you set this rule in 2016. We're just going to hold you to our own rule. It was wrong then, but if it's what's sauce for the goose is sauce for the gander, that it should apply equally in all respects. So that's where I think the hypocrisy comes in, really predominantly on the Republican side. But I think Biden and Harris have made a strategic or rhetorical error in not fully articulating what their reason for being upset with the Republicans is.
I've heard people say that McConnell was referring to situations where it's divided party rule. President, White House is under one party, Senate under the other. And in that sense, the Senate, led by the other party, has the prerogative to choose whether they hold the hearings or not. But you're saying that you don't think that the history applies in that case?
Yeah, I mean, if that is what McConnell was saying, in effect, that all he's really saying is, if we have the majority in the Senate, we can do as we please, which is obviously true. I mean, what he's saying in 2016 is we have divided government with a Republican Senate, so the Republican Senate can hold up the nominee. And then in 2020, we have a Republican control and a Republican White House, so we can proceed. All that is saying, that's not articulating a rule or a principle. That's just stating the fact that the Senate can if the majority leader is effective enough, can operate along party lines if it so chooses. Of course it can if it so chooses. That's just the sort of might makes right articulation of the obvious. What he was saying in 2016 was, because we have this presidential election on the horizon, the normal considerations should be suspended. And if that applied in 2016, you can't consistently argue it doesn't also apply in 2020 just because you have a different party occupying the White House. If what he wants to say is, sure, we have the power to approve a nominee, to delay a nominee, to reject a nominee. If that's all he said, then people would say, okay, you're just saying you're going to work your will. And that's politics. And people may have been upset that Garland didn't get appointed, but it would not have been based on a sort of concocted principle that he sort of pulled out of thin air.
Well, I think your point earlier is quite apt when you say that this is like a two-sided, it's an arms race essentially. And I think one of the things that for the Democrats, I believe Obama's White House counsel, Catherine Rumler, she essentially said that if it was the parties were switched in 2016, she would have recommended the same strategy. So I think there you kind of see that sense. Now, you alluded to the court packing. President Roosevelt's famous attempt to pack the court. Democrats are considering that now. What can you tell me about that episode in American history? I mean, obviously, it's usually considered one of big blunders of FDR's administration. He was usually someone who was quite politically keen and understood how to marshal support. In this case, that wasn't the case. So how has that affected the idea of court packing? What lessons does that have for the current potential attempt?
Yeah, I mean, there's a lot that can be said about it. And I recommend to your listeners a wonderful book called called Supreme Power by my friend Jeff Schessel, historian. Mutual Contempt is another book he wrote. And it really is sort of become the definitive go-to book on the FDR court packing. FDR was sort of riding high off re-election in a second landslide in 1937. And he'd been frustrated even before his re-election by a conservative Supreme Court that was striking down a lot of key pieces of the New Deal. And so the solution they came up with was that for each justice, I believe it was over 70, that the president would get to appoint another justice, hence expanding or packing the court. What he didn't count on was how unpopular this would be, not only among Republicans and conservatives, but in his own party. He had a hard time getting Congress to support it. letters flooded the White House telling him what a mistake he was making. There were already concerns that the strong government approach that characterized the New Deal was threatening to make FDR, some people said, into a dictator or something like it. So this just reeked all the more of a power grab and not sort of abiding by another branch of government having its equal weight. People point out there's nothing in the Constitution that decrees that the Supreme Court must have 9 justices, and indeed the size has changed over time. But it hadn't changed in a long time when FDR did this. And of course, it hasn't changed since. And so even though the 9 justices is a human political invention that we Americans have come up with, it has attained a kind of sacrosanct status. And I think to tinker with it, to threaten to change it, seems violative to people, even to a lot of liberals, even to a lot of Democrats. The people who are talking about it, I think, are being a bit ignorant of history. It's become, they talk about Social Security sometimes as the third rail of politics, not to touch it. I think the number 9 justices, is something like a third rail. I think, if Biden were to be elected, if he were to try to change it from 9 to 11 or whatever, there would be a huge backlash and it would be a big political disaster for him. It certainly was for FDR, who had a lot more power and standing and goodwill than Biden does. So it's a very dicey issue, and I think some people are being a bit too cavalier about it.
Right. And you mentioned the idea of a might makes right approach. And it kind of strikes me, first of all, when FDR, he was elected, he won one of the biggest landslides in history, is 46 out of 48 states. So he had a lot of might behind him. And I think it struck a lot of people as a blatantly political move. And there's kind of this equilibrium that you mentioned as far as having 9 justices. This is kind of, if we can't agree on everything, this is at least the number we can agree upon. It seems like that episode, FDR's court packing, is a cautionary tale to anyone that wants to pack the court today. The Democrats lost 72 seats in the House in the 1938 election after the court packing scheme, 7 in the Senate. Also, Justice Ginsburg herself, a lot is made of her dying wishes, but she's actually quoted saying, quote, 9 seems to be a good number. I think it was a bad idea when President Roosevelt tried to pack the court. If anything, it would make the court look partisan. So again, that's adding to your point there. What do you see the future of court nominations? Where do you see the future going? I mean, is this just going to be an arms race that just gets worse and worse to the point where the courts will change every, there's going to be a court packing scheme every time now? How do you, or do you think things will kind of level off? What do you think?
Well, it's always hard to predict the future. I do think a second unfortunate side effect of the emphasis on court packing, as it were, on expanding the number of Supreme Court justices, is that it's diverting a conversation that might more helpfully be about other kinds of judicial reform, perhaps ending life tenure, 18-year terms. There's a whole community of people who have come up with lots of solutions that might actually have some bipartisan appeal that wouldn't be seen as just, we're in charge now, we're going to ram through our plan. And if you can come up with some bipartisan reform, I think, for example, we've come to recognize how important life tenure is. People are living longer. Presidents are making a point of appointing justices at relatively young ages. Amy Coney Barrett, Kavanaugh, Gorsuch, all very young. Kagan, pretty young. So this is a pattern, again, sort of on both sides. And there's sort of there's some danger in that. I mean, it was not too long ago David Souter just decided to leave the bench. I think Washington was never really the thing for him. But now we have, justices staying on until their dying day. An interesting sidelight to the court packing effort of 37. A student of mine, Judge Glock, did a lot of research on this and has published on it. A lot of those four horsemen, or the older conservative justices who are frustrating FDR's agenda, they had their pensions cut just a few years before under Herbert Hoover as part of an austerity measure in the Great Depression. During the middle of the whole court packing fight, Congress actually restores their pensions to what they had been before. And this actually encourages them to retire. So, maybe that's part of the solution. Maybe we need to think about ways to encourage justices to retire a little younger. I mean, some of them, John Paul Stevens still writes wonderful things for the New York Review of Books, and he's, 100 or so. I mean, so it's not that age necessarily makes one an enfeebled justice, although it's happened. I mean, in Bob Woodward's book, The Brethren, he reported that William O. Douglas had become incontinent on the bench. I mean, he should have retired. So there's a lot, I think, that can be done in a good faith reformist effort that would be nonpartisan, that might help sort of find a way out of this morass. But I do think so long as our country is so deeply divided, and the Supreme Court is just one arena in which we see this. We see it in media, and we see it in where people are choosing to live, and we see it in Congress and so on. So as long as this division and polarization obtains in society and the political arena in general, I'm not sure the Supreme Court can be protected from it very easily.
An ominous note. One thing I'll say, one thing I'll say is that before we conclude is that the court does not seem to be any less important than it is. It seems like it'll only get more important. And according to the docket, it seems that Obamacare hearings will begin a week after the election, and abortion cases in Texas and other states are just an appeal or two away from the Supreme Court. Same thing goes with DACA, despite the court's decision. And of course, any dispute involving the presidential election could find itself at the feet of the court. There's also a copyright dispute between two small companies. They're called Google and Oracle, so that could end up being on the court pretty soon. But Professor Greenberg, we really appreciate you being on our show. For our listeners, he's written the books Nixon's Shadow and Republic of Spin. Make sure you check that out. He's also a contributing editor and columnist at Politico Magazine, so you could check out his works. He's usually in the history department, so those are the Politico articles that I love to read, being a history nerd. So, Professor Greenberg, we appreciate all of your insight, and we thank you for being on the show.
It's been terrific. Great talking with you.
This American President is produced by myself, Richard Lim, and Michael Neal. If you like what you've been hearing, you can help us by leaving a 5-star review on Apple Podcasts or wherever you listen to our show. We are a proud partner of Evergreen Podcasts. Please visit evergreenpodcasts.com for more shows you might enjoy. I'm Richard Lim. We're back next time with more This American President.